everyone. Welcome back to the Divorce and Separation Coach's latest episode. I am looking forward to this conversation. Today, we're going to be talking about alternative dispute resolution options, and in particular, collaborative law. Now, a lot of us are familiar with the different options, but there's often misconceptions and misinformation. And so I thought it'd be helpful to dive a bit deeper, get a bit more insights, and understand how collaborative law can help, how it works, and what it is. So I'm delighted to be joined today by a true expert in this field, Suzanne Kingston. Suzanne is a solicitor, a collaborative lawyer, an accredited family mediator, and an arbitrator. And she's got over 30 years experience in this field. She advises and supports her clients on a wide range of issues, including complex financial matters, children arrangements, prenuptial agreements, cohabitation matters, just to name a few. Suzanne is known as the Queen of Mediation and Arbitration, and she's taught all over the world. So it's a real honor to have you here today. Welcome, Suzanne.
Thanks very much, Chloe. It's great to be here.
So maybe we should start with the big picture in order to help set the scene. Could you talk us through the various alternative dispute resolution options and maybe explain how collaborative law fits into that picture?
Yeah, certainly. So essentially, the court and the Ministry of Justice are really pushing people now to try and stay out of court if at all possible, which sounds counterintuitive, but that's really what they want. And so there's lots of different methods of doing that, from perhaps a couple just having a discussion at home around the kitchen table, discussing how things might be resolved between the two of them, and then taking their discussion to court directly to have a court order made, or alternatively to take that to their solicitors for their solicitors to help them, advise them finally, and then have a court order made. It is really important to have a court order made, so that's why that step is undertaken. It may be that instead of doing that, the couple decide to go to mediation. And in mediation, there is someone like me who's an independent, neutral facilitator, can be a solicitor mediator like me or a non-solicitor mediator. And that facilitator helps the couple reach a solution in relation to whatever they bring to the table. So that's discussions around divorce, the children and parenting plan, and financial matters. And there's lots of different ways of mediating. You can mediate with your solicitors present, without your solicitors present, on virtually or in real life. You can have the mediator shuttle between the two rooms, or all of you can be together in a room. It is important to have independent legal advice if you are mediating, so that your lawyer can sign off on the mediated agreement. And then the same process takes place. The agreement is sent to court, the court is notified that you've reached that agreement in mediation, and then the order is made. I'll come to collaborative practice last, because that's what we're really going to be focusing on today. So I just want to say a few words about arbitration. In arbitration, it's a private judicial system really outside court, but the arbitrator is effectively a judge. So the arbitrator determines what should happen, and the arbitrator can do that either in relation to financial matters or children matters. And then once the arbitrator has given their award or determination, that is made into a court order typically as well. So there's a range of options. But collaborative practice is really something that came over from the States about 20 years ago. And in collaborative practice, it's about teamwork. It's about the couple and both collaborative practitioners, so both lawyers, working together to try and reach a settlement that suits everybody. And the idea that I can always remember when I first was taught about collaborative was that if someone was looking from the moon and looked down and looked into the room, they wouldn't necessarily be able to tell which lawyer was representing which client, because there's such effective teamwork. Everything really happens in the room. There isn't that much correspondence that goes on in collaborative. And you have to have collaboratively trained lawyers working for you. And also there are collaboratively trained divorce coaches, independent financial neutrals. So you can often have a third party, another person in the room helping, advising, bringing everything together. So that's the basics.
Well, I think that it helps everyone to have that framework. So in that context, then, when would you recommend people leverage collaborative law rather than any of the other alternative dispute resolution options?
I think in particular, when you have a good relationship with your spouse, where you think that you would be able to sit down comfortably in the room with them and discuss things. I mean, obviously, we understand that all of those discussions are going to be fraught at times and difficult, but where you feel able to do that, where there's a good measure of goodwill, there's not too much of a power imbalance, where you want to really dig deep and perhaps think about your relationship as well, perhaps bringing in a divorce coach to help with that. So, for example, thinking about how you want to communicate and communicate in the future. And one of the tests that often the clients say is, really, I've come to collaborative because I really want to go with my husband, my ex, to our daughter's graduation. I want to co-grandparent our grandchildren. And they're the sorts of litmus tests that you have in thinking about whether collaborative is appropriate.
Yeah. And are there situations where it's particularly well suited, where you would systematically use or encourage people to use collaborative law?
Yeah, I mean, I think the one that really leaps to mind is doing a prenup. Because if you're doing a prenup, obviously you're not getting divorced.
Yes.
And that's right at the outset of your relationship. And it's about working well together and perhaps modeling how you're going to deal with difficult conversations in the future in a very safe environment. So I would really urge people to think about that rather than going to lawyers, where it can become very positional if you're dealing with prenups.
Right. And that's the tone, I guess, for that kind of collaboration going forward as well, and if marriage breaks down.
Yeah,
And
exactly.
so as a collaborative lawyer, when you've got that hat on, how different is your job compared to that of a traditional family lawyer?
Well, I think that most good family lawyers should always be trying to think of ways of reducing the tension and the stress in relation to a case in any event.
Yeah.
But obviously, if you're a family lawyer and you're involved in very gritty litigation and it's very, very contentious, then you are basically, using your legal skills to their absolute utmost. And, you are thinking of strategically how to get the very best for your client in a court scenario.
Yeah.
Whereas when you're acting as a collaborative practitioner, you are thinking more holistically about the family and the team and what would probably be best for the children, for example, rather than the sole function of getting the very best, the win for your particular client, which is what litigation is all about.
Yeah, it's a very different mindset, isn't it? And back to your example about looking from the moon, you wouldn't be able to know who's representing whom. I think that's a really good way of looking at it. And so, are there any prerequisites to using collaborative law? How does that work?
Well, I mean, there are some things that you have to really engage with. And one, I think, is the participation agreement. So if you want to do things collaboratively, then the lawyers and the clients, and if there was another party involved, a neutral of some sort, would sign the participation agreement. And the participation agreement says that you won't go to court. And if you go to court, then you'll sack your current lawyers and you'll appoint new lawyers. That sounds really counterintuitive. And when I first heard about it, I thought, well, this just can't work. It's ridiculous. But actually, what happens is people work very hard to reach settlements and work in this forum really well in order to undertake that. So for me, I've seen it work in practice many times. And I really think that that's the key, this team working approach, and knowing that you can't hold on to this lawyer, the lawyer that you cherish, that you really want to hold on to, if you don't stay in the collaborative forum. The other thing you need to do is to do what's called an anchor statement. And that is a statement about why you're coming into this process, so that if over time things become a bit wobbly in dealing with the collaborative, you're able to reflect on why you decided to do this.
Yeah.
It doesn't have to be long, but I think actually making that really focused decision to prepare a statement like that is really, really helpful. And it does help when you reach sort of tricky moments in the collaborative case.
Yeah. Right. So does each party write their own, or how does it, if they
They
work?
they write their own, and what we've learned over time is that typically they're sent to the lawyers first, the lawyers to look at and discuss, because we want them to be roughly the same. We have had we've been in terrible situations in the past where one person has said 2 lines, another one, somebody's written an essay. So we want them to be appropriate. We want them to be more or less the same
Yeah.
in terms of length and tone.
So you're looking for the same level of commitment, basically, from both parties, ultimately.
Yeah.
I can
Yeah.
see how at the beginning there might be good intentions, but because inevitably there will be conflict and there will be some difficulties to overcome, that's where you need people to stay the course. So what would
Absolutely.
you say are the key benefits to collaborative law?
Well, I think, as we've indicated, working well together, modeling how your communication could go in the future, staying on very good terms so that your wider family could, for example, meet up in the future and you could be in the same room. I mean, I've done a lot of litigation, and I can tell you now that not many people who've been through litigation really want to be at their daughters' weddings together, for example. That really isn't something that happens. So having that sort of co-parenting, co-grandparenting relationship going forward, also reducing down the level of tension and stress and the harm that is caused by litigation.
Yeah.
When you're in litigation, you have to pitch one party against the other, and they may say terrible things about the other person, which is then very difficult to row back from.
Yeah.
So I think maintaining a good tone in terms of how you're dealing with the dispute, and also something that's very current at the moment in England and Wales is privacy and transparency, because the courts are opening up more. They want people to understand what happens in the family law arena, so that it isn't some sort of dark arts, that people understand what's going on. And so they're basically saying that a number of cases will be open to the press. There will be reports, not identifying children, obviously, but there will be reports. And I really think that if you want to keep your case private and confidential, then staying out of court, and by this, obviously, you could do this in mediation as well, any of the out of court dispute resolution that I mentioned at the beginning of this interview, keep it private. And lots of people do actually want confidentiality.
It's an important concern, definitely. And so would there be situations where actually collaborative law wouldn't be the right approach? When would you tell people not to go down that route?
Well, I think if there wasn't sufficient goodwill, I think if one person felt the other was going to be dishonest in terms of disclosure, I think that if they didn't feel that they would be able to work together, even having lawyers there, if there was a history of domestic violence, if there was a history of alcohol dependency or drug dependency, they're the sorts of things that you'd be looking out for to consider whether or not it'd be appropriate.
So you're really looking for a balanced conversation ultimately between two people who can have a proper negotiation. Great, that's really helpful. One final question. I promise it's the last one, but could you give us an example of a time where you've seen collaborative law really save the day and be absolutely the right approach for a couple?
Yeah, so I'm going to give 2 examples. One is a prenup, and that was where the husband-to-be was very had great financial acumen. He worked in the city. He knew all about money. He'd made a lot of money. And the wife-to-be really was not financially savvy at all. And she requested that her parents come to the meeting. Now, obviously, that would be unheard of in any form of litigation, or would be very unlikely, but the husband agreed, and we had some really interesting debates and discussions, and I felt that they really embraced doing a prenup in this way.
Yeah.
They thought carefully not only about the financial things, but they also talked at length, probably not with the parents in the room at this stage, but about things like how they were going to resolve arguments in the future, what they were thinking in terms of children and parenting styles and stuff like that. And I felt that it was a really, really good way for a young couple to establish their relationship and get married. So that's one. The other one is where it was a really complicated case, where there was a lot of money involved, there was a lot of difficulty in terms of tax issues, etc. And we did ask a financial neutral to come in, and he was able in the room to provide tax advice when we needed it, to explain quite complicated issues around carried interest. It was a private equity case. And so I felt that, again, if we had been doing that in a traditional sense, particularly in court, that would have taken years and it would have cost a lot of money.
Yeah.
But because everyone was on hand to be able to deal with it and keep it moving forward, it was really, really fantastic in terms of potential outcome.
Yeah, that sounds great. That's really helpful. It really brings it to life. So thank you for sharing those examples. I will leave you alone and we will conclude this podcast. But thank you so much for your time, Suzanne. It's been really helpful hearing directly from somebody who's involved in all these different sorts of ADR options. So thank you for your time and thank you for your insights and have a great day.
Thanks very much. Great to meet you, Chloe. Thank you.
Take care.